Hello everyone, and a very warm welcome to all of you attending today. My name is Philip Hoddell and I'm the Chairman at Burkitt Long. I'm delighted to welcome you all to this Wednesday webinar. Burkitt Long are offering fortnightly webinars on a range of different legal subjects. Before the summer break, we most recently talked about construction law and commercial rent arrears, and future webinars will include looking at some of the myths that surround divorce, and then a session on trademarks. If you're interested in any of our webinars, please sign up at www.burkittlong.co.uk/events. Now, today's seminar is presented by Tim Ogle, a partner in our wills, trusts and probate team. And Tim's going to be talking about how to plan for the future across the generations, covering some important legal and tax points, and then of course taking your questions at the end. It sounds as though it's going to be a fascinating discussion, and I will now hand you over to Tim.
Thank you, Philip. So my name is Tim Ogle. As Philip said, I'm a partner and solicitor in the wills, trusts and probate team at Burkitt Long. And as Philip also said, we'll take questions at the end. So do please make use of the question and answer facility. So I'm then tasked this afternoon to look at some key intergenerational planning points, some sort of headline points, if you like. But I think the first question is, what is intergenerational planning? And I think it includes things like discussions as to who is to inherit, assisting aging parents with financial decision making and who looks after them if they lose capacity. It can cover lifetime gifting, inheritance tax planning, and paying for care fees. Those are the sorts of issues that I think are part of the intergenerational planning debate. So it's taking steps to ensure, as far as you can, a smooth transfer of wealth down the generations in line with your wishes. Okay, so we've got the usual warning there that we always put at the start. But I think in looking at intergenerational planning, the most obvious and arguably the most important starting point is an up-to-date will. And why would you want a will? Well, the main reason must be to have the last word, as these people did, and they're all real examples. To my first wife, Sue, whom I'm always promised to mention in my will, hello, Sue. Or there was the one that said, to my daughter, I leave £1 for the kindness and love she has never shown me. Or there was Roger Brown, this is my favourite, who left £3,500 for his friends to use for a boozy weekend away to a European city. In the event, they went to Berlin and afterwards said, we spent most of it on beer, the rest we wasted. What a good way of describing it. And then finally, in 1990, a rich Portuguese man had no offspring and very few friends, and no doubt wanted to irritate those that he did have. So he chose to leave his estate to 70 names he chose at random from a Lisbon phone book. But that aside, believe it or not, there are other good reasons, besides having the last word, for having a will in place, rather than being one of the 60% or so of all adults in Britain who have not made a will, or the 1/3 of people who die without a will. Of those, just pausing on the stats for a minute, of those who have not written a will, 22% are over the age of 75 and 39% are aged 65 to 74. And there are issues such as not wanting to talk about death and cost perhaps, but the number one reason that tends to come through is just simply being not getting round to it. These people then have to rely on the intestacy provisions, which we'll touch on briefly in a minute. So we've got this first slide up there, the benefits of a will. So some of them are fairly obvious, but with a will, of course, you choose your executors. And those are the people who you trust to administer your estate. It's an important role. They have a legal duty to carry out their function properly. They are charged with disposing of your body, collecting in the assets, paying debts and liabilities, settling all tax affairs, preparing estate accounts before distributing out the residuary estate to the beneficiaries that you have chosen. It's a very important job, obviously, and you must choose wisely. You might have particular funeral wishes you wish to include, as well as burial or cremation, and we do see some interesting ones. Most importantly, perhaps, you get to choose who gets what. Now, the starting point in English law is something called testamentary freedom, as we saw from our examples. It's your estate, and you can do what you want with it. You might want to remember friends, particular family members, or charities who would not otherwise inherit. You might want to specifically exclude a family member who would otherwise inherit, perhaps leaving a side letter to explain why you're doing as you are. However, this is subject to a statutory right for certain types of claimants to claim on the estate if they do not feel that you have left them reasonable financial provision. If you have young children, you will want to state who you will want your guardians to be if your partner has also not survived or not survived you. You might, and we see these quite often, want to make particular provision for family pets. And there is, of course, an opportunity in your will to reduce or minimise inheritance tax, which is at 40% over your nil rate bands. In a will, this might be very simply by use of the spousal or charity exemption or the residence nil rate band by making sure that you leave your home to lineal descendants, but more about inheritance tax later. We get the next slide. A special mention perhaps when looking at intergenerational planning of problem children. Now, this is a slide I've nicked from the family team, and the poor little girl, she looks so sad, doesn't she? It makes your heart weep in a way. And then the next one, please. So an absolute gift in a will gives you certainty, but that may be risky if the beneficiary is young or immature or unreliable or perhaps vulnerable to third-party pressure. The law allows a child to take at 18. That is when they, in legal terms, can give good receipt for capital. So the executors are able to discharge their duty by paying out to a child who is 18. But at 18, your child or the child may still be one of the things that we see there. They may still be immature or unreliable or subject to third-party pressure, or they may divorce or become bankrupt, and your legacy to them is then part of their assets and vulnerable to attack by others. You can ignore a child completely in your will, but they would then have an opportunity to claim on your estate, as I mentioned. It's not easy to do, but a child or someone treated as a child or financially dependent on the deceased, they are all categories of claimants who may claim on an estate if they do not feel that reasonable financial provision has been made for them in the will, or indeed has been left to them under the intestacy rules. So you might want to think about the use of a trust in your will, whether this is for problem children or indeed otherwise. And this is where your trustees are the legal owners of the assets in the trust, but they hold those assets for the benefit of others. A discretionary trust, which is referred to there, that creates a class of beneficiaries who may benefit from the trustees exercising a decision in their favour in the future. This, of course, will only come about if it's a will trust on the death of the testator. And the testator will, generally, it's good practice to leave a side letter with their will, setting out how they would like their trustees to act in the future, giving them some guidance. But this letter is not legally binding on the trustees, but is certainly very, very helpful. Therefore, very important to choose your trustees very carefully. They will typically be the same as your executors, but they don't have to be. It's important to choose them carefully because they are the ones who ultimately decide who gets what and when. But in this way, and this is the big advantage of a discretionary trust in your will, they are able to make decisions in the future, taking into account circumstances as they change, and perhaps a long way into the future after your death. So this type of trust can be particularly useful to protect a vulnerable beneficiary, such as a child or young adult. It enables your trustees to see how they mature later on and, as I say, to make decisions in the future as circumstances change. Now, a life interest trust is different to a discretionary trust, and this is where the beneficiary takes an asset, perhaps the home. They have the benefit for their lifetime, but on their death, that asset passes on to whomever the deceased person has stated in their will. Now, life interest trusts like this are common between couples and are often used on second marriages, for example, to ensure that the children of the first to die inherit that asset when the new partner dies later on. Otherwise, the risk is that the survivor, who owns the asset absolutely, does a new will at some point, leaving everything to their own children. And we see that happen quite often. No one is to blame as such. Life for the survivor has simply moved on, and perhaps they haven't stayed in touch with their deceased partner's own children. Trusts like this in a will can also help to protect assets from care fees, because it is the trustees who own the asset or the part of the asset, often the family home, as I've said, or half of it, rather than the person going into the care home. Thus, it's not included when assessing what assets the person has and what they should contribute to their care fee costs. So that's particularly helpful if the first person has died, so that the survivor is then living in the property by themselves, because if the survivor then goes into a care home, the property is empty and may be assessed for care fees. So if some of it at least is in a life interest trust, then at least some of it is protected from care fees. So what you do want to do is avoid these, the intestacy provisions. You probably can't read those particularly well, but the message there is that they're quite tricky, quite complicated, and what you want to avoid. But in the first instance, under the intestacy rules, your spouse and children or civil partner will be first in line to inherit your estate, which may be what you would want anyway. So you think, well, that's not too bad. But even then, you need to bear a few things in mind. For example, if children are to inherit under the intestacy rules, they will do so at 18. Now, I don't know how responsible you were at 18, but if I'd come into a large sum of money at 18, there wouldn't have been much money left by the time I was 19. Fortunately, I had no money at 18, and almost 40 years, one wife and 4 children later, I still don't. But hey, that's marriage for you and the subject of a different webinar. But another common problem when someone dies without leaving a will under the intestacy rules and leaving a spouse and children might be where their estate is over £270,000, because in this situation, the intestacy rule says that the spouse doesn't receive everything. Under the intestacy rules, the spouse will get the first £270,000 and half of everything over that amount. But the remaining half of everything goes to the children, which may not be appropriate in your case. What about those people who are living together as a couple but don't get married? Many people wrongly believe that there is something known as common law husband or common law wife, but these titles simply don't exist in law, certainly not for these purposes. If you want your partner, your unmarried partner, to be provided for, it's essential to make a will, as unmarried partners do not feature in that intestacy distribution list set out by the state. They would be left to make a claim on the estate on the basis of having been financially dependent on you. You may also see, I think you'll struggle at the bottom of the chart, that if you die without any family, your estate ultimately passes to the Crown, which is very rare to happen, but I doubt many people would be happy with that. So moving on to lasting powers of attorney. And the way I think about it, if wills are about death planning, then lasting powers of attorney, or the acronym LPAs as they're often called, are about lifetime planning. They enable you as the donor, the person setting up the lasting power of an attorney, they enable you as the donor to appoint attorneys to act on your behalf in your lifetime when you cannot. They enable a third party, such as a bank, to legally deal with your attorneys in relation to your affairs. In effect, your attorneys step into your shoes and can act on your behalf as if they were you. You can give guidance as to how your attorneys can act or not act through preferences and instructions. You can notify other people, if you wish, that you are setting up these lasting powers of attorney. But they must be registered at the Office of the Public Guardian before they can be used. And that process takes about 3 months. It's not quick. So if you're thinking about doing them, it's good to get on with them. They're very important documents to have in place. A recent survey I came across by the Office of the Public Guardian found that 70% of those members of the public question wrongly thought that a close family member could deal with their financial affairs without a lasting power of attorney, and they simply cannot. So if you have a sole account and your husband or wife or partner wants information on it, they won't be able to get it unless they have a lasting power of attorney, perhaps some other specific arrangements with that institution. So there are 2 types of lasting power of attorney. The first is property and finance, which covers dealings with banks, building societies, pension providers, buying and selling a property, stockbrokers, and the money side of things. But it can be used while the donor still has capacity, provided it's registered, if the donor wishes that. And that can be very helpful if you as the donor, if you're temporarily ill or absent or abroad, or you simply wish your attorneys to act for you for whatever reason. The second one on the next slide is the health and welfare lasting power of attorney, which does what it or covers what it says on the tin, and it covers medical treatment, general care matters, so dealing with doctors, dentists, and care homes. Unlike the finance one, this one can only be used if and when the donor loses capacity, and it enables the donor to give their attorneys the ability to accept or refuse life-sustaining treatment on their behalf. That is a particular part of the document that needs to be completed. That is to say, whether you do or you do not give your attorneys authority to give or refuse consent to life-sustaining treatment on your behalf. So it's a position of some responsibility over and above what someone would be just as a family member, if you wish. So a health lasting power of attorney must be consistent with any living will or advanced decisions document that you might have in place. And this is where someone sets out the type of medical treatment that they wish to refuse in the event that they lose capacity. You don't want those to be contradictory at all. The fundamental point about lasting powers of attorney and the relationship is that your attorneys must act at all times in your best interest, and they have a strict legal and moral obligation to do so. Lawyers don't often talk about morality, but here we are, the two completely coincide. But it's obviously critical to only choose attorneys who you completely trust. I strongly advise people to have lasting powers of attorney in place, but not if it would mean that you would be appointing attorneys who you don't completely trust. It's generally sensible, if possible, to have more than one attorney, should something happen to that attorney, but only if you've got other attorneys who you completely trust. And where you have more than one attorney, it's very important that they can work together. If you don't have lasting powers of attorney in place, should you lose capacity, then your loved ones would need to make an expensive and time-consuming application on your behalf about what happens to your assets to the Court of Protection, perhaps taking up to a year. Good for us, but less good for you. The Court of Protection would then decide who acts on your behalf, what happens to your assets and how your money is spent, rather than you setting up those arrangements in your lasting powers of attorney. An insurance bond is needed, and we have a specialist team that deals with these applications now. So, you know, certainly in my view, there's little doubt that lasting powers of attorney are really important, and I think they're needed more and more as more and more of us are living longer. Our bodies can be put back together, but our minds are less easy to preserve. So, in summary, if you like, clear benefits to lasting powers of attorney, allowing you, as it says there, or your loved ones to retain control. Just a couple of final points before we move on from this slide. We'll just go back one. We're not quite there yet. We won't hit them with a photo of the Ogle family quite yet. Interestingly, I thought I was listening to someone who had been a managing partner in a top London firm, who wasn't a wills, trust and probate lawyer, but was talking about looking after your clients, your private clients, but also your business and commercial clients. And I was struck by him saying there are 3 critical documents that you should not only advise your clients and potential clients to have, but you should implore them to have. And so I was listening to, oh, what are they going to be? What are they going to be? And very simply, it's a will, it's a finance lasting power of attorney, and it's a health lasting power of attorney. So that's maybe the one message you take from today, above and beyond anything else, I think. Intergenerational planning can get very complicated, but certainly those are the key simple things to think about. And just finally, I don't know whether anyone picked up, it was a little while ago now, during the pandemic, and Kate Garraway, who's a TV presenter, breakfast TV, and has done various things, but she had a very sad story to report of her husband who caught COVID and had lost capacity. I'm not quite sure, I think he's slowly recovering, thankfully, but he lost capacity, and she was talking through some of the incredible difficulties she had. So she not only had to deal with him not being well and all the trauma and fear involved in that, but just on the administrative side, the great difficulty she had in sorting out his affairs, or trying to. And the irony being that they had talked about putting lasting powers of attorney in place, but hadn't quite got around to it. So now I can hit you with the Ogle photo, very quick case study, and I think more or less the last thing on lasting powers of attorney. So there we are, that's the Ogle family. My 3 sisters and I are attorneys to my mum on a joint and several bases, so that any one of us can act on her behalf, which gives us flexibility because we all live in different parts of the country. At that point, a few years ago, that photo, my mum still had capacity at that time, although not after a glass of sherry at Christmas, which is when I think that photo was taken, but using the finance lasting power of attorney. For example, when she still had capacity, I was able to sort out her pension query. So she still had capacity, but it was just convenient for me to be able to help. Now she's lost capacity, we run her finances, and one of us will regularly make decisions for her with the care home and doctor. So, you know, lasting powers of attorney are not just for those of advancing years, but also for the young middle-aged, like all of us, I'm sure, in the audience. And you just see that little face at the back of the photo. That represents the next generation down, my son Johnny. So poor soul, he is now 18 and one of my attorneys, along with my wife and 2 adult daughters. So, you know, maybe there's an example of intergenerational planning through the generations. So, as I said at the start, intergenerational planning may also involve, I think will involve in appropriate cases, thinking about whether there are appropriate steps to save inheritance tax. Now, inheritance tax is at a whopping 40% above your nil rate band allowances. So, to soften the blow, I've got some inheritance tax jokes for you. I apologise for these. I asked members of my team to contribute, and there's 5. So if you don't, you can blame them. Although maybe we should have a little vote, and after the 5, you can vote on your favourite one. So here's the first one. Don't forget, not me to blame. Today, my son asked for his inheritance. I told him, over my dead body. They get worse. I know you're all laughing yourself silly at home or wherever you are. So number 2, I inherited my dad's collection of shallow, flat receptacles with a raised edge used for carrying, holding or displaying articles. I feel betrayed. 3, I don't want to be an alarmist, but my father's just died and left me his alarm company. Well, number 4, cat says to dog, 9 lives is great, but the inheritance tax is what kills you. And finally, the last one, although this is my favourite. The good news, the solicitor said to the will beneficiary, is that you've inherited a genuine Van Gogh and a genuine Stradivarius. The bad news is that Stradivarius wasn't much of a painter and Van Gogh made lousy violins. So there we are. And you've got the cartoon which has been put up for you. So one day, son, 60% of this will be yours. It doesn't quite have the same effect as all of it will be yours, but there we go. OK, returning to some sense of propriety, perhaps. Now, although only about 5% of estates pay inheritance tax, you don't want yours to be one of them if you can avoid it. The Office for Budget Responsibility forecasts inheritance tax to raise 6.7 billion in 2022-23, where we currently are, which is actually very small beer compared to the amount raised by VAT, which I think is the chief revenue raising tax, and that was 130 billion in 2019-2020. And I think it's 372 billion I've got written down here, the estimated lifetime cost of the government's COVID spending. And that's before we start thinking about the government covering the energy crisis. So actually, in context, it's not a big sum, but on an individual level, potentially at 40%, it's a huge amount. And in my experience, it is the one tax that people hate more than any other. It's the one that we all seek to avoid. So let's look at some key planning points. And just to recap a little, so your estate pays inheritance tax at 40% on the value of your net estate on your death above your nil rate band of £325,000. That's the allowance that we all get. It hasn't gone up for a long time, and I don't think it will be, but that's where it is. If you have a residential property which you leave to a lineal descendant, so I think I mentioned a child or a grandchild, your estate has up to a further 175,000, making £500,000 in total. So in this way, a married couple or civil partners leaving everything to each other and then to the children, thereby utilising the spouse exemption, can benefit by up to £1 million between them in their joint estate, if you like, of nil rate bands. If you remember back in 2015, I think it was, George Osborne at the Conservative Party conference stood up and said, you've got to be a millionaire before you pay inheritance tax. Well, sort of, if you're not married or you don't have children or you don't have a residential property, possibly not, but you can see the point. So that's my way of background, but in terms of basic IHT planning points, the first one is always to spend it. You've earned it, you spend it. To hell with the kids and anyone else, spend it. But beyond that, if you're in a couple, but not married, sorry to kill the romance, but it is certainly inheritance tax efficient to be married or in a civil partnership, to utilise the spouse exemption if you are leaving assets to each other, so that you have the ability to use the unused nil rate bands. This is a real common point, so I'll just, forgive me if you're familiar with it, but I'll just kind of spell it out. So take me and my wife, my lovely wife, Josie. I know my mother-in-law's in the audience, so I will add that in very quickly. Just celebrated our 25-year wedding anniversary yesterday. So if I die first and I leave everything to Josie under the spouse exemption, then there's no inheritance tax to pay, even if, wouldn't it be lovely, I had £10 million and I left all of that to my wife, then that would all go under the spouse exemption. It doesn't matter what level it is. But that then means that my estate hasn't used my nil rate band or my residential nil rate band. So on my wife's death, she's got her own nil rate bands and my unused ones to use as well. So she would, or her estate would have £1 million of nil rate bands to use. And for a lot, that's probably going to cover you, even in this area where a property price or the average property is whatever it is. If you're married with children in that classic kind of family unit, those nil rate bands will often cover estates. Beyond that, an important point in inheritance tax planning is that one should never let the tax tail wag the dog, as we say, and always ensure that you have enough assets for the remainder of your lifetime, which may have many twists and turns in the years ahead. So it may be great to save inheritance tax for the kids, but if you give it away, you might regret that later on because you might need those assets. But subject to that, you can give up to £3,000 away in your lifetime under the annual exemption, and that is then outside of your estate immediately. And if it's unused, it can be carried forward to the next year to make it £6,000. Now, not a lot, but if you use it regularly over a 10-year period or whatever, then that can add up. 10 years of £3,000, £30,000, if that's out of your estate, that's already saved £12,000 in inheritance tax. You also give a number of small gifts, up to £250, they can be given away in your lifetime to different individuals, and up to £5,000 as a wedding gift to a child. Beyond these exemptions, if you give assets away and reserve no benefit from them and survive 7 years, then the asset is outside of your estate for inheritance tax purposes. But you must reserve no benefit. I'm afraid you can't have your cake and eat it. You can't give a house away but still live there, or even still live there from time to time, because for these purposes you would not be deemed to have given that away at all, and it would still be in your estate. So if it goes, it's got to go, which is why I was advising caution about this, not letting the tax tail wag the dog. Make sure you care for self and partner in the first instance before you think saving about inheritance tax for the benefit of others. But if you do have spare cash or surplus income each week or month, then you can use the normal expenditure out of income exemption, which is gifts from surplus income on the slide there. If you can afford to gift money away on a regular basis and maintain your normal standard of living, then this is potentially a very valuable exemption to mitigate inheritance tax. The money is outside of your estate immediately, and there's no limit to what you can give away in this way. I remember listening to an ex-revenue inspector at a seminar a little while back, saying that the revenue don't like this exemption and want to change or remove it as it's just too expensive for them. He had known it to include, for example, annual city bonuses on a regular basis, even only every year. Although I would recommend something more regular than that, such as monthly. But the trick is to keep good records so that your executors are able to claim it. If you can think about your executors in several years, 3 or 4 years time, trying to trace back the records to show that this was surplus income, to show what your income and expenses were, therefore this was income you didn't need, that's going to be very difficult. So the trick is to do it as you go along. Actually complete the inheritance tax form that your executors will have to complete as you go along. Gifts to charities, whether in lifetime or on death, are exempt from inheritance tax and can actually reduce the rate of inheritance tax from 40% to 36%. So that can be used if there's a charity that's close to your heart. There's something called business property relief. You can get 100% business property relief. That's available on a transfer of assets used in a business or for unquoted shares, so a little bit more specific. 50% for quoted shares with control or assets owned personally and used in the business. And there's also something called agricultural property relief. That's available on transfer of agricultural property, whether 100% or 50%. That's a little more specialised. But the final thing is about investment products. And there are, I think suffice to say today, certain investment products which you can purchase, which can fit in very well with estate planning. There are certain investment products, and they might include investing in AIM shares, for example. Okay, so moving on to the final area, lifetime trust. We've talked about trusts a little bit in your will, so they would only come into being on your death when the will is crystallized. Until then, it's ambulatory, I think the word is. It doesn't have any effect until you die. But some lifetime trust, this is what some people do. So rather than gifting assets away absolutely in your lifetime, or indeed on death, you might want to consider the use of a trust. Now, I've mentioned these, as I've said, but essentially enabling you to pass assets on, but keeping control. Your trustees, rather than your children or the beneficiaries, are then the owners of the trust fund to guard against the death, divorce, bankruptcy, third-party influence, maturity, risks and issues that I've mentioned. If you're setting up a lifetime trust like this, you can be a trustee yourself. People sometimes ask about family trusts. This is where the settler, the person setting up the trust, the person putting assets into it, they set up a trust giving themselves a life interest in the asset, such as their property, with it to then pass on to whomever they choose on their death, often their children or perhaps their spouse. The settler, the argument being the settler would then no longer have the burden and responsibility of ownership of the property and has made provision for it in their lifetime whilst retaining security of tenure. Simply gifting the asset to children would risk that security of tenure if the child dies, divorces, etc. There would then be an inheritance tax charge if the value of the property is over £325,000, but no capital gains tax, provided it's the principal private residence. Just a little bit of detail, if it's not the principal private residence, then transferring property into a trust rather than to someone absolutely can benefit from what's called a holdover claim by the settler, whereby any capital gains tax charge is deferred to be paid until when the asset is eventually sold. So very helpful in particular circumstances to transfer out or gift to the trust where there's a big capital gain that would otherwise be crystallized. Now, the property, one of the reasons it's done, the property, well, one of the consequences, the property in the trust would not then be a part of the settler's assets for care fee purposes, but, and a big but, provided they can show that they have not deliberately deprived themselves of the asset to save care fees, but they have transferred the property into the trust fund for other reasons. And as soon as someone comes into the office and says to me, oh, I want to save some care fees in my lifetime, what can I do with my property? We've got difficulties because the real reason would be to save care fees. Very quickly, a second type of lifetime trust is a pilot or spousal bypass trust. And this is where the settler, you might have heard of these, it's getting a bit more specific now, but where the settler sets up a discretionary trust in their lifetime with a nominal sum of perhaps £10 in it. The intention being that the trust will receive a large sum in the future, such as death in service benefits, and the idea being that this then avoids that sum passing to the spouse on death and then being caught in their inheritance tax estate, being the survivor. So it just avoids going to the surviving spouse because the surviving spouse might be the one with the inheritance tax charge. And then the third example, very quickly, of type of lifetime trust that we might see that people think about as part of this intergenerational planning is a trust for a vulnerable person, such as a disabled child. Very briefly, the trust must be set up so that the vulnerable person is the principal, although not necessarily the exclusive beneficiary. And the advantages of these trusts, which we will probably talk about separately, I think, from today, is that they enjoy or can enjoy preferential tax treatment. Okay, so that's the guts of the webinar. If you've got any good inheritance tax jokes, please let me have them. You can see that I'm in need of a bit of a refresh. But before we take questions, been asked to say we're sending a recording around to everyone that signed up to today's webinar. That goes around tomorrow morning. We'll also include a link to a short feedback survey, and we'd appreciate it if you could complete it so that we can try and make our future webinars as good and as relevant as possible, because we want to make them geared to what you want, what's helpful to you. And as Philip said at the start, this is one of a series of Wednesday webinars. I think our next one is on myths on divorce. But if you're interested in our future webinars, please visit our website or our Eventbrite page to sign up. Okay, so I think I've covered those points. So any questions? Katie, do we have any questions at all?
Thank you, Tim. Yes, we have one from Darren, who asks, if you have multiple trustees on a power of attorney, what happens if they do not all agree on what action should take place?
That's a very good question. So if you've got multiple attorneys on your lasting power of attorney, they all have to agree, essentially. And if they don't, then ultimately it would be one for the court to resolve. So I think one of the key things about lasting power of attorney, it's preferable to have more than one, but two things: that you trust them all, as I mentioned, but also that they can work together, that they're going to get on, to try and minimize that risk. But, you know, it may happen, and if it does happen and they can't all agree, then ultimately it would have to be one for the court of protection or for the lawyers and the court to get involved, because you don't have a majority decision type situation.
Thank you, Tim. We did have a couple of questions that were submitted in advance. The first one is, are there disadvantages of a trust?
Yes, so typically if we might think about, let's say, your will and leaving everything absolutely, or the alternative I mentioned is perhaps instead of doing that, you might leave your half share in the house on a life interest trust to your surviving spouse or partner, perhaps for care fee reasons. It's effective in a will because you're not depriving yourself of assets because you've died. So that can be the potential advantage, in that you can save, and it could be tens of thousands of pounds in care fees. But I suppose looking at the other side of the equation, the disadvantages potentially, I don't think they're huge, but putting that will in place is a little bit more expensive, I suppose, is the first one to say. But for the trust, there are certain administrative requirements. So if you've just got a half share of a property in there, you won't have any income, so there won't be any tax returns to do. But if the trust does generate income, then there would be some tax returns to do. You will have to register that trust with HMRC, regardless of whether it's paying tax. That's not a tax matter, but that's a money laundering matter. New rules that have come into play. And so I suppose there's a little bit of paperwork to do, a little bit of administration. So it's, I guess, not for everyone, but potentially big advantages using that life interest trust care fees advantages. The disadvantages tend to be along those sorts of administration requirements, if you like. So you need someone who's going to be prepared just to deal with those, but they're not, generally speaking, they're fairly minor.
Thank you, Tim. Another one we had submitted in advance was, who can claim against a will?
So we touched on this a little bit. You read an awful lot, well, not an awful lot, but those cases hit the headlines. They're in the newspaper on page 3 or 4 about the long lost son or disgruntled daughter who's complaining that they haven't been left anything and their undeserving sibling is taking it all. They just conspired against me and all that sort of thing. You read about those disputed estates. But these claims are not easy. They're fairly difficult. You only, of course, hear about those few that make the headlines. But to bring a claim, it's not anyone who can bring a claim on an estate. You have to be within one of the 6 categories of claimants. So that's a spouse or an ex-spouse or someone who you living together as husband and wife, or you are financially dependent on the person. So that might be perhaps someone akin to a child, someone financially dependent on the deceased, or a child, or someone treated as a child. So I think there's 6 categories of claimants. You have to be in one of those to be able to bring a claim. If you're not, you can't. But if you are, and you don't think that reasonable financial provision has been made for you, you can potentially bring a claim. But legal action is not easy, it's expensive. To try and ward that off, you can't stop someone bringing a claim if they're within one of those categories. But we would recommend, for example, that when you do your will, you do a side letter and you do the letter to the judge, basically saying, this is why I haven't left any money to my son or daughter or whoever it is. The reasons are these, and you set them out. You say that you haven't seen them for the last 20 years. You say that I want to direct my estate to my other 2 children because they're the ones who I lived with, they've stayed in touch with me, they've looked after me. You explain your thinking, you set it all out. You show that you're rational, that you're not just being nasty, that you've considered it in your mind, you've balanced everything up, all those sorts of things. But that letter's not legally binding on anyone, it's not legally binding on the judge, but that can be something to hopefully help minimise the risk of a claim.
Thank you. Then we've just had a new question submitted, and that is a trust mainly useful when you have sizable assets or even in smaller cases?
Yes, I think there is probably some sort of de minimis level below which setting up a trust is probably not worth it. There's no fixed amount, but given that there's going to be a little bit of administration to do with it, it's probably not worth putting in a few £1,000s or something like that, particularly if lawyers or professional trustees might be involved, because they're going to have costs, which is going to eat into the capital amount. So there's no set amount, but I would be thinking much more closely about the worth of setting up a trust if it's only a few £1,000s or something like that. I suppose the other thing is, one of the reasons you're setting up the trust perhaps is to try and avoid some of the risks that I've mentioned about giving the money absolutely, perhaps. And if it's only a small sum, then of course the risk of giving that to whoever it is a lot less. But you know, I'm looking at it, I suppose, more from a professional trustee's point of view, where there's costs. If you're running everything yourself, there's no reason you can have a small amount of money in the trust if you think that's helpful to you and it's worth the amounts of time that you're going to spend on it. So no, the usual lawyer answer, it sort of depends. There's no fixed amount, but it's a valid question to raise. Absolutely, there is a sort of trade-off. Is it going to be worth the administration of setting up a trust?
Thank you, Tim. We have a question from Carol. If an executor has now died, should they be removed from the will?
Yes. Well, if nothing is done, then obviously they can't carry out those duties, and the other executors, if there are other executors, will just carry out that function. And when it comes to applying for the grant of probate, a death certificate will be produced for their executor to show to the probate office why that person is not part of the application. So I think if you've lost an executor in your will, have a look at who the remaining executors are, assuming there are some, and if you're happy with them remaining as executors, then that is fine. But if you've only got one executor and that one executor has died, then I would certainly be recommending that that person does a codicil or a new will to specify who they want their executors to be. If there's no executor at all, then it would be left to a beneficiary to apply to be administrator, which can be done, but it isn't quite as easy and straightforward.
Thank you, Tim. We have a question from Lisa. Would setting up a family trust with parents' main home and additional properties placed in it help to reduce inheritance tax for children?
It's going to depend upon the values that we're talking about here. So one of the things to be looking at is where, if the value going into the trust is more than £325,000, then there is an inheritance tax charge to pay straight away at 20%. So that would be one issue to look at there. But if it's beneath that level, so that there's no charge to immediately pay, and it's not going to go up in value so that there aren't any subsequent charges, then it could potentially be out of your estate, but provided that the person who is putting it into the trust in the first place doesn't reserve any benefit. That would be one of the critical points there. So we'd have to look at the values, we'd have to look at what's intending to be done, but potentially so, yes. That's a tricky one. If I forget, was it Lisa? Lisa, if you want to get in touch directly afterwards by email or something, we could just have a little look at that one.
Thank you, Tim. And the final question for today is, how do trusts in wills save care fees?
So we've sort of touched on that. That would be where you say own the property jointly as what's called tenants in common, so you own an identifiable half. And let's take me and my wife Josie again. So if I die and I leave my half share of the house into a life interest trust, that means that Josie, my wife, can remain in the property for the remainder of her lifetime because she owns half the house herself, and the other half she's got the right through the trust to remain there. But if Josie or I was to go into a care home now, the value of the home wouldn't be taken into account because there's still someone living there. So the risk is for the survivor of us. If the survivor goes into a care home, then the house is empty and the value of the home will be part of the assessment of what you own for care fee purposes. But in this situation, if Josie as a survivor goes into a care home, then she only owns half the house herself because the other half is in the trust. That's the way, broadly speaking, it works. It isn't perfect because Josie still owns half the house and that can be assessed for care fees, but at least half the house is protected. Forgive the pun, but it's a halfway house, if you like. It can be very successful. If you like, if there's a risk of someone going in a care home for perhaps a longer period of time, and we know how expensive care homes are, a minimum of £1,000 a week. But in this case, Josie would have half the value of the house to be put forward for care fees, but if that is used up, then at least the other half is protected, as I say. And it is a way, people like it, it's a way of at least guaranteeing not all the assets are used up in care fees, but at least half the value of the house can be passed on to children or whomever.
Thank you, Tim. That's all the questions for today, so I'll leave you to conclude today's webinar.
So simply thank you very much for joining us, for giving us your time. We will review any questions that might come through which are not answered and contact anyone we haven't had time to respond to. But thank you very much once again and good evening.